The video shows Deputy Douglas Johnson's encounter with inmate Enzo Escalante awaiting trial for murder. He ushers him toward the wall of the San Fernando courthouse. Escalante responds with a couple of punches. Deputies rush in to pull another inmate away while others help Johnson bring Escalante to the ground in order to restrain him.
So the foundation of this entire lawsuit is false. Everything on this lawsuit is false. And when you take this entire I'll go to the next one. When you take this entire thing into context, you realize that there was a lot of people working in concert and coordination. That includes the LA Times. That includes people that obviously want to defeat me electorally. That includes the board-appointed Inspector General and the Civilian Oversight Commission.
It was the LA Times who initially broke the story last month with the video of the deputy kneeling on the head of that inmate, and the sheriff wants to know who released that video to them. It has a newspaper now vigorously defending its First Amendment rights. The sheriff also came ready with his own evidence to dispute a cover-up into the use of force inside of the jail.
Entirely orchestrated for political purposes only. And too bad I don't have people, reporters like from the LA Times. Maybe you need to start clarifying exactly what you did with this and who did you get it from and when did you get it? So that's a question for you to answer. So with that, we're not going to take a question from you. Anybody else has a question?
It's nothing but retaliation. It's a smoke screen. It's to throw people off the trail of what the allegation is of what was done in his department that was wrong, and he should be announcing an investigation.
Sheriff, are you going to answer the question? You placed your picture up there alongside two other people. You talked about it in terms of a criminal investigation. Is this Los Angeles Times reporter under investigation by the department?
Well, the act is under investigation. All parties to the act are subjects of the investigation.
Welcome back to Legal Dissent, where we evaluate your constitutional rights before they're taken away. Thank you so much for joining us, and as always, if you enjoy our content, please do help spread our message of government accountability and transparency by subscribing to the channel, liking this video, and interacting with us in the comments below. It really does help us out a lot in the YouTube algorithm. On March 10th, 2021, at the San Fernando courthouse, Deputy Douglas Johnson was struck by an inmate. Johnson restrained the inmate and then placed his knee on the inmate's head for 3 minutes. Very reminiscent of how Officer Derek Chauvin used his knee in the George Floyd case. All of this was hidden by the LA Sheriff's Department until Elaine Shekhamedian, a reporter for the LA Times, released a story with the video in March of 2022. In the article, she alleged that sheriff officials attempted to cover up the incident because they feared the negative light it could shed on the department, going on to say that they were worried about the optics of the kneeling given its similarity to the George Floyd case.
He had his knee on the man's head as they were trying to handcuff him. And once they handcuffed him, he kind of stopped moving and wasn't resisting and was complying with the orders. And from that point on, the deputy continued to leave his knee on the man's head for another 3 minutes.
Arlene Chickmedjian obtained the video and the internal force review that included a commander's comments.
He recommended an administrative investigation and also said that charges should be sought against the inmate who very clearly on the video punched the deputy. He said in the report that a decision was made by sheriff's officials, unclear exactly who, not to charge the inmate because they didn't want the video to get out. And the reason why is because they feared, they were worried about the optics. I did get a response from the sheriff's department saying that when Sheriff Villanueva found out about the incident in October of last year, he immediately ordered an investigation and relieved the deputy of duty.
Sheriff Villanueva alleges that he did not find out about the incident until 8 months after it occurred, and then took immediate action relieving the deputy of duty. All of this is occurring in the midst of Villanueva's re-election campaign, and sources are stepping forward to claim that the sheriff watched the video much earlier than he had said. Just a few days ago, on April 25th, 2022, Commander Alan Cassiano filed a tort claim against the sheriff, alleging that the sheriff had blocked installed investigations into the excessive use of force. And when he was exposed, he moved to cover up the incident, lying repeatedly, and retaliated against Cassiano and other whistleblowers. In response to this complaint, the sheriff's department scheduled a press conference labeling it as his opportunity to discuss false claims made by a recent lawsuit filed by a disgruntled employee.
Okay, March 10th, use of force incident involving the deputy of the San Fernando court. You already know that. Video viewed by the area lieutenant, by the unit commander, and viewed by Convoy Operations Assistant Sheriff and Court Services Division Chief and Commander Castellano, who was the one who filed the complaint. So we know that happened on March 10th. March 19th, IAB received a notification 9 days later. And this is standard protocol in a use of force investigation. So March 24th, 14 days later, 2 weeks later, the use of force package is approved by the lieutenant. Then a day later, use of force package is approved by the captain. Okay? And then April 13th, the IAB case was open. This is internal affairs. Investigation was opened. That's on April 13th. So it doesn't sound much like a cover-up here, as alleged. Okay, then we go, now here's where there's a big gap in time. From the time it was approved by the captain to the next person up on the chain of command as a commander, there's about a 3-month gap. All right, and that is subject to why did it take that long. Then, from there, July 12th, use of force package approved by Court Services Division Chief, who has since retired. Okay? And then use of force package sent to Discovery Unit. This is a normal chain of events, notwithstanding the delay right here. But this is for all Category 2 uses of force. This is standard procedure for the entire department's operations. Custody, patrol, court services, the entire department. That is how it works. Moving on our timeline. I know we've kind of flipped it. We can't keep it going that way. But September 5th, Commander Eli Vera assigned to Court Services Bureau. November 18th. Yes, this is the important date. This is a date that I was shown the video. The internal criminal investigation was opened. It's a very important date. So the question was, why was it not launched at any point prior to November 18th? So this is where it gets weird, because it never happened prior to November 18th. And there's no memorandum, there's no documentation at all in the entire case file of a lieutenant, captain, commander, or division chief signing a memo until after this date. And what happened on this date, Kelly Porowski, who has since retired, she actually was notified in person by the undersheriff to write, to make that happen. She was in charge of Professional Standards Division, and she knew exactly what was missing. Where is a memorandum from the concerned division chief? So on November 22nd, right here, actually they opened up 2 things. But let's go here. Before we get into that point, on this same day, an order was given to relieve the deputy of duty. The very next day, the individual involved, the deputy, takes a leave of absence. And he's gone all the way till December 6th. So the first day he returned to work, he was relieved of duty, which was on December 7th. Now, this is where it gets really fun. Because right here, somewhere around here, in March 25th, March 26th was my campaign kickoff. But this entire week, it was one after another. It was a hit parade from the LA Times. Inspector General identifies 41 sheriff's deputies who allegedly belong to gang-like groups. This information is a year old. It's stale. They were sitting on it. And there's absolutely no actionable information on here for anybody. But it made for a good clickbait for the LA Times. Go to the next one. Here's another one. LA County panel launches investigation, deputy gang. More clickbait. No authority to appoint anyone to give their subpoena power to. And they got pro bono attorneys. So more clickbait. Go to the third one. And here's the one. Right before, this is on Friday. Fearing bad publicity, LASD covered a case of a deputy who knelt on inmate's head. Well, this is a false headline right there. No, there was individual within a division that engaged in something that was of concern. But they were not definitely acting on behalf of the department.
This poster made by the Los Angeles Sheriff's Department depicts 3 people. The one on the left, Eleazar Vera, is actively running against the current sheriff and is his political opponent. The one on the right, Elaine Shekhamedian, is the reporter that wrote the article exposing the excessive use of force video to the public for the first time. Now, the sheriff is claiming that he is launching a criminal investigation that includes his political opponent and a reporter for, according to Sheriff Villanueva, receiving stolen property. That is the video, and committing obstruction of justice by writing the article.
When we launched our criminal investigation, these are the crimes that we're looking at. Because remember, what was taken from the department was an active criminal case. All right? So, when two or more people conspire to engage in any of the conduct described below, that's a conspiracy. Burglary, entering a building to commit grand or petite larceny, or any felony. 502, unauthorized access of a database. 503, fraudulent appropriation of property by a person to whom it has been entrusted. Like case files, videos that belong to active criminal and admin investigations. Breach of public duty, this is California, and then a federal one, Title 18, U.S. Code, Section 1030, prohibits the unlawful access of a computer database in the excess of one's previously granted authority. So we have all these things that are obviously the subject of the criminal investigation, and this is not a leak, this is actually obstruction of justice. Go on to the next slide. So here are the three individuals that we want to know a lot about. This person said he gave it to this person. This person is actually authorized to receive the completed investigation. But somehow it landed in the hands of the third person, the reporter from the LA Times. So now the question is, when did this happen? That's a very important question. So these three people have some important questions to answer. When did they do this? So the three standard questions in any corruption cases: what did you know, when did you know it, and what did you do about it?
The sheriff's point of view is that everyone is lying about him to beat him in the upcoming election. The commander who filed the lawsuit, his political opponent, the inspector general, the Civilian Oversight Commission, and the reporter are all creating a grand conspiracy against the sheriff.
So the foundation of this entire lawsuit is false. Everything on this lawsuit is false. And when you take this entire, go to the next one. When you take this entire thing into context, you realize that there was a lot of people working in concert and coordination. That includes the LA Times. That includes people that obviously want to defeat me electorally. That includes the board-appointed Inspector General and the Civilian Oversight Commission. A lot of people working overtime, and they're doing it as best they can, so there'll be more of this nonsense thrown at me until June 7th, but it is what it is. Entirely orchestrated for political purposes only, and too bad I don't have people, reporters like from the LA Times. Maybe you need to start clarifying exactly what you did with this, and who did you get it from, and when did you get it? So that's a question for you to answer. So with that, we're not going to take a question from you. Anybody else has a question?
Sheriff, could I ask you a question?
Go ahead, Frank.
Is Aileen from the LA Times under investigation by the department?
The matter is under investigation. All right.
Is she under the investigation?
The matter is under investigation. This is stolen property that was removed illegally from people who had some intent, criminal intent, and it'll be subject to investigation. We will not be the only party investigating this. There will be other agencies will also be thoroughly investigating this and monitoring what we're doing, and it will be handed over to the appropriate prosecutorial agency so they make a determination.
Sheriff, are you going to answer the question? You placed your picture up there alongside two other people, and you talked about it in terms of a criminal investigation. Is this Los Angeles Times reporter under investigation by the department?
Well, the act is under investigation. All parties to the act are subjects of the investigation.
Is she one of the parties?
Well, she received the information, and then she put it to her own use. What she receives legally and puts to her own use, and what she receives illegally or the LA Times use it, I'm pretty sure that's a huge, complex area of law and freedom of the press and all that. However, when it's stolen material, at some point you actually become part of the story.
It is obvious that Sheriff Villanueva wants the LA Times to name their sources and wants to prosecute the reporter for some alleged conspiracy to challenge his authority. Journalists and the press are protected in the United States by the First Amendment and enjoy freedom of speech. This enables them to be able to challenge government officials and positions. For example, other countries like Russia do not enjoy this freedom, as they are facing jail time for negative reporting on the war in the Ukraine, or for even just calling it a war. It is clearly established that government officials are not legally allowed to search, intimidate, or arrest any individual for publishing content that the government does not like. The freedom for journalists to protect their sources on a national level was evaluated in Brandsburg v. Hayes by the United States Supreme Court, when they consolidated 3 cases into one. All of these cases were about reporters who were subpoenaed to testify and reveal their sources who were accused of conducting criminal activity. The Supreme Court held that there is not an additional layer of First Amendment protection granted to reporters to protect them from testifying before a grand jury and providing information on their sources. However, they punted much of this responsibility to state legislatures to develop their own shield laws to protect journalists exercising their freedom of expression, of which 49 states have enacted shield laws that do provide greater protection for journalists in these situations. California, for example, has it in their state constitution and provides that press employees shall not be held in contempt by any body having the power to issue subpoenas for refusing to disclose the source of any information procured. In this case, it's very difficult to see the sheriff having any type of legitimate claim against the reporter. There is no probable cause from the information available to assume that the reporter has committed a crime. In my opinion, this is nothing more than a bluff from an angry official who is attempting to divert attention from his own misconduct and intimidate others from speaking out. The LA Times released a statement claiming that they will vigorously defend Shechamedians and the LA Times' rights, putting the sheriff on notice that if they search the property or data of any LA Times employees in this matter, then the department will have directly violated state law and clearly established constitutional law. The very next day, Sheriff Villanueva backpedaled on his stance, and the department released a statement saying that they have no interest in pursuing or are pursuing criminal charges against any reporters. What do you think? Should government officials have the ability to threaten reporters with criminal investigations and then backpedal without repercussions? Does the public have the right to know that their government is engaged in these types of activities? Should reporters have the freedom to expose these stories without the fear of retaliation? Let us know in the comments below. And remember that no matter who you are, you have value and you have rights. Do not be afraid to use them, and we'll see you next time right here on Legal Dissent.